The VA finally shows some flexibility with respect to paying realtor commissions. Nice thing to see. That's the good news of the week. The bad news, which is also bad news for home sellers. The DOJ came out and spoke at court this week in the MLSPIN Nozelec case and stated that they don't want to see commissions offered anywhere. They want no offering of compensation anywhere. In addition to that, the National Association of Realtors filed for a rehearing, a request for a rehearing because of the recent ruling in the appeals court. In addition to that, our attorney, Mr. Michael McDonough, the general counsel for the Lamacchia companies, is burning midnight oil, doing an entire write-up on steering, what it really is, fiduciary duties, and all of those subjects. That'll be out next week. Now, let me break down these things in further detail. The VA came out and they talked about how they're going to provide what they said a temporary bridge. So basically, they're going to pause these hard rules that they have so that realtors and buyers can negotiate how the realtor is getting paid in a buyer agent situation with their client. What I notice in some of these articles, I'm going to read a couple of the quotes, and then I'm going to actually show you the current guideline, which is very interesting. So they've basically said they're temporarily removing the restrictive language until a new policy can be enacted. Someone from the VA, the deputy director, Michelle Corden, said, "We want them to be able to exercise their right in the marketplace to buy a house." She's referring to veterans. Happy to see that. And this is why they're going to have this so-called temporary bridge. NAR was obviously very involved in this, as was the Mortgage Bankers Association, so I applaud them both for working on that. There's another thing I saw here, a comment from Shannon McGann. NAR launched an all-hands advocacy effort on this issue, meeting with VA officials, engaging with lawmakers, and rallying our industry partners to ensure this prohibition was lifted. So this is a victory for the work at NAR and for the Mortgage Bankers Association. But truthfully, the biggest victory, which is just tremendous news, is for home buyers that are using VA loans, for our veterans. Some of you may remember when I did the debate with the plaintiff's lawyer, I had told him, you will have the reputation as the person who affected VA borrowers. So I'm glad to see some regulations changing there. I think that if VA is agreeing to pause their hard rule, clearly they're going to loosen it up in the future. And I want to clarify that because many realtors are confused by it into thinking that this means VA will now allow you to finance commissions. That's not the case. Let me read the rule, then I'll get into that. So this is straight from the VA website, from a pamphlet they put out, pamphlet 26-7. Brokerage fees. Fees or commissions charged by a real estate agent or broker in connection with a VA loan may not be charged to or paid by the veteran purchaser. While use of buyer brokers is not precluded, veteran purchasers may not under any circumstances be charged a brokerage fee or commission in connection with the services of such individuals, since information on property available for purchase and financing options is widely available to the public from a variety of sources. VA does not believe that preventing the veteran from paying a buyer broker fee will harm the veteran. So you can tell this is a guideline that was put in many years ago. I'm sure it was put in place long before we got to where we are now, which is roughly 90% of transactions being co-broked, meaning a buyer having their agent and a seller having their agent. So that's the hard, fast rule. That's a little bit of commentary from the articles, but let me just expand on this a little further because I'm already noticing some realtors that are like, oh, problem solved. VA will pay our commission. Not necessarily. What this does is it puts VA, hopefully, from what I can tell, on an equal playing field with the other government-sponsored enterprises, with Fannie Mae and Freddie Mac, which is out of the FHFA, and also with FHA, and USDA, which is a part of HUD. VA and VA lending is a part of HUD. They allow buyers to pay their agent directly out of pocket if they so please at closing, so long as it doesn't impact their ability to qualify for the loan. They also allow a portion of the commission or an entire commission, whatever the amount is, to be paid from the closing cost credit. That's what those entities allow. VA was steadfast against that, as I just described from this rule that I just read you. They're basically saying they're going to pause that rule, and they are allowing it to be, essentially, it sounds like the others, until they figure out new guidelines. So credit to the VA. Good for you all. Thank you on behalf of VA buyers, realtors like myself, broker owners like myself who have dozens and dozens of agents who are representing VA buyers every single month. We're happy to see that. So I thank you for that. Now moving on to the DOJ's comments, the Department of Justice comments in court this week here in Boston. And then there's a lot of commentary here that I'm going to read. RAS Media put out a great article about this, great coverage by them, and I just want to read it. The DOJ, okay, so let me read this. Jessica Leal, a lawyer representing the DOJ, called the NAR settlement an improvement, but implied it was not enough. We believe offers of compensation should not be made anywhere, but certainly not on the MLS, Leal said. That's their position. I don't agree with it. I think that it's not a good decision or a good position, and I don't want to give away what our wonderful attorney, Mr. McDonough, is going to talk about next week, but one of the things that he points out is they had a different attitude back in 2007. Funny how things change and how things change with new administrations and new employees in these institutions. Leal said the DOJ was not currently supporting or opposing the NAR settlement, even as other lawyers involved in the case said it would be hard for them to make decisions without knowing where the DOJ stood on the issue. You know, this goes back to what I've mentioned before. The DOJ is kind of like the boogeyman who puts comments out, but then goes in and isn't totally clear. And that's a difficult thing for the defense attorneys to deal with. They want to prohibit the seller from offering compensation at all. That's what Seth Klein said, a lawyer representing the plaintiffs. Now, I thought this was interesting. He went on to say, I think from the statement that their ultimate position on what they think the world should look like, and I don't necessarily disagree, he says, but that's an issue for a rule, a legislative change, or a regulatory change. Folks, I've mentioned this in my prior videos back, I want to say in February, early March, after the DOJ's initial statement of interest. The DOJ cannot just come in and say, commission offering from sellers is totally banned. Now, can they work with other regulatory authorities and create regulation or rules? Well, I'm sure if they flex their muscles enough, they can. But in my eyes, okay, I don't see how they would make this totally enforceable to sellers without law. And to pass a law, that's an act of Congress. That's a tall order in my view. I think that's a very tall order, and I really don't see it happening because how could and why would a lawmaker, whether Democrat, Republican, or independent, take away the right of a seller of any product, never mind just real estate, to offer compensation to someone who brings them a buyer? Think about all the other industries out there where sellers offer compensation. Hey, you bring me someone, I'll pay you X. Boating, and that's the latest one that these money pocket picking lawyers are going after now. Now they're after the yacht industry. Okay, these people are nothing but money grabbers in most cases. Side story. Anyway, the point I'm getting at is why and how could they force that upon a seller? I don't see it happening. But it's clear that that's their position. And this attorney, Seth Klein, I think does a pretty good job with his words here, where he points that out in the earlier part of his quote was, the current dispute between us and the DOJ is saying that they would not want there to be any ability. Well, ideally in their statement, they say they want to prohibit the seller from offering compensation at all, said Seth Klein, a lawyer representing the plaintiffs in the MLSPIN case. Can't say I really appreciate Seth Klein's work in this case, because I don't, because he's on the plaintiff's side, but I think he has some good commentary. In his final comment here, pointing out how it would have to be rule change, legislative change, or regulatory change. I agree with him on that. But I don't see a seller listening to anything other than legislative. Leal requested, so the attorney requested, that Judge Saras would set the next hearing for the case to be June 21st. I thought that was interesting, and the judge agreed. So there's going to be a hearing over this on June 21st. And at some point, it could be as soon as today, could be at some point in the next week or two. I think they have until June, early June or somewhere in there, that they have to file their opposition. So remember, DOJ has stuck their nose in. They put out a statement of interest. Then they went into court the other day and made these comments that I just read to you. But now MLSPIN has their chance to file their rebuttal. Some other MLSs around the country filed an amicus brief a month or two ago, and I thought they did a hell of a good job pointing out the flaws in the DOJ's argument. But now MLSPIN is going to have that ability, and then they can argue it out in front of the judge on June 21st. So I'm sure I'll be seeing you before then, but I'm sure we'll be talking about it at some point after. Next and last. Katie Johnson, yesterday, NAR's attorney, put out an update. Today, NAR petitioned the United States Court of Appeals for the D.C. Circuit for a rehearing challenging its ruling that would allow DOJ to reopen a previously closed investigation into NAR's policy. This talks about how, folks, the DOJ violated their agreement. They made an agreement with NAR in 2020. 8 months later, they undid the agreement. NAR went after the DOJ and originally was successful. DOJ appealed it, and more recently, the appeal court came down and agreed with DOJ that they have a right to reopen things. I don't think that should be the case. Let's think about that. I'm a business owner. Business owners across the country, people with far bigger businesses than me, okay? Who the hell would want to make an agreement with the DOJ for the next 100 years if they know that 8 months later they could undo that agreement? It appears to me that it is NAR's attitude and desire to take this all the way to the Supreme Court. And I'm happy to see it. I hope they do. I think they will be successful, and they should not back down on that. This will set a precedent for decades to come. The Department of Justice should not have the ability to just undo an agreement. Why? Because an administration changed? That's how America falls apart. And it's not something that should be possible. I do want to clarify, though, because some realtors and even some other industry folks are getting confused. This argument is not with respect to the DOJ's positions and what went on in the DOJ settlement or case. It is strictly only an argument for whether or not the DOJ should have been able to upend the agreement and bail out of it. That's it. That's what this argument is. But I believe that NAR should stick with that argument, and I applaud them for going through these motions. They basically filed for a rehearing, I'm sure, and I'm assuming that that is part of the steps involved with taking this to the SJC, which will probably take a year. But all the power to NAR on that. As I said, and I'll mention it again, our wonderful, very intelligent, highly capable general counsel, Mr. Michael McDonough, is working very hard, burning midnight oil, okay, writing up an entire legal analysis on lots of things that have come up over the last couple of weeks, steering and fiduciary duties and all other items related. We will be releasing that next week at some point. If I had to bet, it will be Wednesday or Thursday. Looks like it's going to be a 5 or a 6 page write-up. And I think it will have many people very, very interested. That's all, folks. Thank you. Stay tuned in to Crush It in Real Estate, to recases.com. And for many updates along the way, follow me on Instagram at AJ Lamacchia. Thank you all. Have a wonderful Memorial Day weekend.